Today in this part we will discuss about court procedure and the evidence. Court procedure and the evidence. And this court procedure, tomorrow you will be doing a role play. Offense, last class we have discussed what is offense, what is FIR. What is the answer of this one? Can a police officer arrest a doctor directly? Then what is the procedure? Yes? Louder, louder. With a warrant? No. What? Yes? Proper medical evidence. Okay, half correct. This side, what is the thing which is done in the middle? A doctor cannot be directly arrested. Okay, before arresting, the opinion of a medical board is required. Doctors from government setup, they have to give the opinion whether this doctor has actually done the negligence or not. Okay, they have to form a medical board. Inquest we have sir has discussed. Summons we have discussed in details in the last class. What do you mean by summon? Then what are the types, what are the forms, who will deliver the summon, and what we will do? You will receive the original copy, sign at the back of the duplicate copy and give it back. Okay. Then you cannot avoid the summons. If you have genuine reason, then only you can avoid, but you have to give your explanation, proper explanation. And if you do not attend someone intentionally, then you are liable to be punished. If you receive 2 summons, these are the criteria already we have discussed. Then, who is a witness? A person who provides evidence about a fact in the court of law under oath. Common witness, then expert witness, we have discussed in details. Doctor will be both common as well as expert. Viva question. They used to ask very frequently. They used to ask, doctor will fall under this and or this. Doctor will fall under both. Then, what is hostile witness? Who will change his statement? Okay, in the subsequent proceeding. Competent witness. Who is a competent witness? Who is an incompetent witness? We have discussed. What is an expert witness? You will be an expert witness when you go to the court. Tomorrow there will be a role play where 2 of you, I think, 2 of you will be playing the role of expert witness. These differences you will get in book. Okay, we have discussed in the last class. This is also a short note which is asked. Common witness, hostile witness, he or she will change the statement later on. Hostile witness. So, this one we'll discuss today. We'll discuss today in details, and tomorrow you will have this as mock court in our department from 12 to 1. Perjury, done. Difference, this one I have shown. Evidence, oral evidence, it may be direct or indirect. I have seen a crime, so I'll go to the court and directly inform that okay, this person has killed this person. I have seen that one. That is oral. Documentary. Indirect means I have not seen directly, but I have heard or seen something which is related, which may be related to that crime. Okay, circumstantial evidence and hearsay. Hearsay means what? That I have heard from someone else, that someone else have seen something, that someone else have discussed the things with me, and I am giving this as an evidence in the court. So I will give a hearsay evidence. The person who has seen will become a direct evidence, direct witness. Circumstantial, hearsay, documentary. All the documents, whatever we can produce, will be documentary evidence. It may be sickness, fitness, disability. MLC full form is what? medical legal case. MLC is medical legal case. This our subject will be full of this word medical legal. Medical legal reports like autopsy report, drunkenness report, injury report, all these things will be medical legal reports. Dying declaration, deposition, FSL means forensic science lab. Fingerprint report, serology report, chemical analysis report, those are all from forensic science lab. Those, then electronic records. This one in the last class I could not explain in details. Usually whenever we submit a documentary evidence, say I am forensic medicine expert, I have done an autopsy, and then this autopsy report is an evidence, right? So it will be submitted to the court. So documentary evidence is accepted only on oral testimony. It means what? That even if I submit the documents, I have to go to the court and explain what is written in the document. Okay? So which one is superior, documentary or oral? Oral is superior. Viva question. Which one is superior? Oral evidence is superior to documentary. Now the answer is why? Because oral evidence, there is a chance of cross-examination. This is the simple answer. Cross-examination. Oral evidence has the chance of cross-examination, so oral evidence is superior, except in few conditions. What are those few conditions? These are these exceptions to the oral evidence. In these cases, documentary evidence is superior. Understood this fact? So in this type of situations, documentary evidence will be accepted. You don't have to go to the court and explain what is there in the document. Understood? So the first two case statements of relevant facts made by a person who is either dead, cannot be found, or incapable of going to the court. Almost same is the second point also. Today I have given one statement, okay, about a particular case. Today I have given a statement about a particular case, whatever I know. In the next hearing, I may not be able to go. Why? I might be killed, okay, I am dead, or I may be paralyzed, I may have some illness, or someone has kidnapped me, I am not been able to go to the court, or any personal reason for which I have not been able to go to the court, okay, incapable of giving the evidence. So in these situations, the statement which I have given in the previous hearing, this is a document, it will be documented. Whatever I will say, they will record everything. That document will be accepted. I don't have to go again. Understood? Same, almost same is the second, where the evidence given by a witness in the previous judicial proceeding is admissible in the subsequent judicial proceeding when the witness is either dead, cannot be found, or incapable of going to the court. Clear? Third, expert opinion expressed in a treatise. Very important point. They usually used to ask about this. What is a treatise? Treatise means, any idea? Treatise means a standard textbook or standard reference. Expert opinion expressed in a treatise. Say for example, I have written something in a report. I have written something in a report. I have also learned from a book. So whatever I have written, the knowledge which I have got is from a standard book. So that standard book or article or any standard reference becomes a treatise. So whatever I have written in that document, it is present in that book. That book becomes a treatise. So that book becomes an evidence in the court of law that I have given my report on the basis of whatever is written in this book. Ideally, court has the power to call the author of that book also. Author of that book, and he may have to testify whatever is written in that book. But it's not always possible. Like suppose I have written something from a book which is written by a foreign author. You cannot expect that a person from the foreign will come and give the statement. It's not possible. incapable of coming to the court. So that document, that book is a documentary evidence and there need not be any oral testimony of the author. Clear? Deposition of a medical witness already taken in a lower court. I have already given my statement to a magistrate, that means to a court, in presence of the accused, and it is already recorded and documented. Now this document can be used if the case goes to the higher court also. You might have seen in movies that I will go to high court. People are not happy, not high court, say person is not happy with the second class judicial magistrate, he can go to the first class judicial magistrate. If there also is not happy, then chief judicial magistrate. Chief judicial magistrate not happy, then high court. If not high court, then Supreme Court. If not Supreme Court, then therefore I told you that to go through that, what is that article in the Constitution of India. If that person is not happy with the Supreme Court judgment, then what is the next? Where he can go? Yes? President. Where is it written? Random guess. Yes, correct. It's the President of India. But President of India, say suppose someone is getting, say, hanging, judicial hanging as the highest death. President of India has the power to reduce that judicial hanging to life imprisonment. The same power in the state is with the who? Yes? Governor. Right? So, I have given my statement and this in a lower court and this is an evidence in the higher court also. Then, reports of certain government scientific experts. What are these government scientific experts? Forensic medicine experts working in government hospitals. Then, fingerprint expert, director of the forensic science laboratory. Then, ballistics from the ballistics department. So, these are all, there are many more, you go through the book. There are certain scientific officers, government scientific officers, whose report is enough. They don't have to go to the court and give the testimony. Public records means what? Your birth certificate. Okay, birth certificate, then death certificate of someone, these are public records. Hospital records, that case sheet of a patient, that is also an evidence. Date of admission, date of operation, consent is taken or not before operation, then what are the medicines given, timely given or not, any overwriting is there or not, any use of whitener is there or not, all these things are taken account in the court. So, if someone asks you which one is superior between these two, oral evidence is superior except in few conditions. What are those conditions? Just now I have shown you. Dying declaration. You have seen this movie? Good morning. You have seen this movie? Somewhat related to dying declaration. Dying declaration. If someone is dying, he is declaring something. Right? So, dying declaration is also known as litem mortem. What does it mean? Definitely you will not know because it's a Latin word. Dying declaration means what? That a person, it is a declaration given by a person. He will declare something. Declare what? That I have been abused or I have been attacked by someone. Dying declaration is not taken in all the cases. Taken in deaths due to unlawful activity. The first one means words said before death. Words said before death. It means litem mortem. What is the second one? It is more difficult. Nemo moriturus praesumitur menter. It means what? It means a man will not meet his maker with a lie in his mouth. Or no one at the point of death is presumed to lie. This is the concept in India, that when a person is dying, whatever he speaks, it will be the truth. Okay, that is the concept behind dying declaration. It means what? It is defined in section 26, subclause A of BSA. It is a written or verbal statement of a person who is dying as a result of some unlawful act. He is informing something that I was killed, I was abused, or I was tortured by my, say, brother or father or mother or wife. They try to attack me, and this is the reason why I am here in the ICU. Okay, so written or verbal statement. And it's an example of hearsay evidence. Why it is hearsay evidence? Any idea? No. Anyone who can explain why it is an hearsay evidence? Yes? Correct. Very good. Because the person is already dead. He has given the statement, now he is dead. So the person who has recorded this one will be the witness. So it's an example of hearsay evidence. Who can record the dying declaration? The best is if the person himself give the declaration. If possible, written and signed by the dying person himself. If not, most of the times it is not possible. A person is dying. You will not open his mask and say, "Aap bolo, aap idhar kyun ho? Kisne mara aapko?" You will not say all these things. Right? Best is if you can record. Or second is magistrate, executive magistrate. This is also not possible most of the times because magistrate will not sit beside you. He will be sitting in his office. So you have to inform to the police. Police will inform the magistrate. Then magistrate has to come. By that time, that person is already gone. Okay? The next one after magistrate, best person is you all, doctor. And this is the most practical scenario. So if someone asks you who is the best person to record the dying declaration, ideally it should be the person himself who will say or who will write in a paper. If not, then magistrate. Which magistrate? Executive magistrate. What is the other type of magistrate then? Executive magistrate, and then another one? Judicial magistrate. Okay, and then comes the doctor. Then it may be anyone, any lay person. It should be done in presence of two witnesses who also should sign the declaration. Now, role of a doctor. And this one we'll have in SDL also if we get time. So you have to do a role play for dying declaration, and long question, short note, practical question, everything you will have from here. Dying declaration. What is your role in dying declaration? First and the foremost is to stabilize the patient. It's not that patient is collapsing, you will forget everything, you will take a paper, you will take a pen and say that, okay, you tell me how you died. No. Hello. You write or you don't write, it's up to you. Don't take photos. So, you have to stabilize the patient first. Okay? And then inform the police. Police will inform to the magistrate to record the dying declaration. If magistrate cannot come on time, then you have to record the dying declaration, and preferably it should be video recorded. And being a doctor, what is your main role? Your main role is not to record. This is the work of a magistrate. Magistrate will come and record. Your main work is to certify the compos mentis before recording the dying declaration. What is compos mentis? Compos mentis means you have to check whether he is mentally stable or not. Okay, they used to ask, what do you mean by compos mentis? Compos mentis means the mental state of that person. If you find that he is not mentally sound, then his dying declaration is invalid. That time he can say anything. If he is not having any mental uh, balance, he can say that, okay, I was trying my wife XYZ or any random ABC has tried to kill me, if he is not mentally balanced. Understood? So your role as a doctor is to certify that he is sound. Medically it is known as compos mentis, before recording the dying declaration, and then after recording you have to sign. The magistrate will sign first and then you will sign. Remember, once you have given the signature in that dying declaration, it means that you have certified that this person was competent to give dying declaration. That means he was mentally sound to give the dying declaration after you have signed. After that, you cannot change anything. Okay? Do's and don'ts while recording the dying declaration. It should be recorded, video recorded preferably, and you should write. If you are taking the dying declaration, you should write in the words which the patient is saying. You cannot use your own words, you cannot modify anything. Whatever the patient is saying, you have to write it. Okay, record it. If the person is not been able to speak, he can always use his gestures. You are video recording this one, so this video becomes an evidence, so he can use gestures. No oath or leading question. I have already explained what is the leading question. What is the leading question? The answer is yes or no. Why you were absent? Why you are absent in all the forensic medicine class? Then I do not like this subject. Why you are absent today? I was having this problem, that problem. Leading question, reading out and then signature. So after you record, you have to inform the person that this is the thing I have recorded, this is the thing I have written. If there is anything to correct, then he has the right to correct, and then he will give his signature and you have to send it to the magistrate. And then the person recording the dying declaration must be present in the court to certify the fact. You have to go to the court. Now the question is, very common question. What if suddenly the person collapses? You are recording the dying declaration and suddenly the patient is collapsing. Now, what you will do? Any idea? Louder. Louder. Stabilize the patient. Yes. What you will do with this dying declaration? You have to correct. When you see that person has become unconscious or patient is collapsing, then you have to stop the recording, note it down. Note it down, the person is collapsing. Try to stabilize the patient first. And then if he is stabilized, then you can record again. But main thing is you have to stabilize the patient first. It's not that you will go on writing and here patient is collapsing. Not like this. Then what was, can a suicidal note found on the close of a disease be considered as dying declaration? Why? That can be fake. Yes. But if it is not, if it is real, then nothing is altered. Can this be considered as an evidence in the court of law? Yes, this is a dying declaration. This is a dying declaration and this becomes an evidence in the court of law. That's suicidal note. Whether it is real or fake, it depends on the investigation. The police or the court will find out this. Police, court, FSL expert, that handwriting expert, all those experts will find out. But yes, suicidal note is an evidence. Dying declaration is not admissible in two conditions. If the person survives after making the dying declaration, it is a dying declaration, means the person is about to die. What if the person survives? Then it becomes invalid. Now what happens next? That time this declaration becomes a corroborative evidence, supportive evidence. In this situation, the person is now living, he has not died. Now this person will go to the court. What happened to her? Not feeling well. Boring class. The person has to go to the court and give the statement, oral evidence. And this declaration which was taken becomes a supportive evidence. Okay? And if the dying person is not having compost mentis as certified by the doctor, in these two conditions, dying declaration becomes invalid. Now there is one more term called as dying deposition. Dying declaration is practiced in India. Dying deposition is not practiced in India, it is practiced in Western countries. This comes as a short note. Differences between dying declaration and dying deposition. Here it is recording the statement of the dying person. Here it is a bedside quote. The other name of dying deposition is a bedside quote. Bedside quote means here dying deposition is taken in presence of the accused, in presence of the lawyer from the accused side also. Here there is no one. It is recorded by the magistrate. If not magistrate, then the doctor, then others. Here it is taken only by the magistrate and it is taken in presence of the accused. Keep this one down. The presence in presence of the accused and the lawyer from the accused side. Okay? Presence of the accused and his lawyer. Here it is no need. Here it is must. Oath not required in here. Here oath is required, as it is a court, bedside court. Oath is required. Cross-examination here is not allowed. Here it is allowed. Leading question not allowed. Here it is allowed. If the victim survives, then it becomes a supportive evidence, corroborative evidence. Here it retains its value because cross-examination was done, accused was present, lawyer from the accused was present. So it retains its value. So which is better? This one or this one? This one. But unfortunately, this one is followed in India, not this one. Okay? This one, I think in the last class I have discussed in short what are the punishments. What is the death sentence? Judicial hanging for citizens. Judicial hanging in army force, air force, army or navy, it is shooting. What are the death sentences in other countries? Some externals might ask. Okay, go through the book. These things I have shown in the last class. Okay, now stages of criminal proceeding. This is in short, in brief, might come as a short note, and some externals used to ask. What happens when a criminal is caught? He is not sent to the jail at the first day. First, it will be an investigation. First stage is investigation. It is done by the police. The viva question is this judicial or non-judicial? Most of you, if you do not read the book, then you will say this is judicial proceeding. But this is done by the police, not by the court, not by the magistrate. This part is a non-judicial proceeding. The police, after getting the information, will go to the crime scene, or someone if informs about the crime, then FIR will be registered, then police inquest will be done, then police will collect the evidence, arrest the accused, record the statements of the witness and record the confession. This is the sequence. Then in some cases the police might send the body for medical legal autopsy. Now after everything, Police have collected the evidence, they have summoned the witness have given the statement. After everything, if police thinks that the accused has not committed the offense, then they will submit the closure report. They will submit the closure report to the judicial magistrate or the court, and they will show innocence of the accused. If police thinks that the accused has committed the offense, then police will submit the charge sheet, police report or challan to the judicial magistrate. Now here you see this part, recording the statement of the witness, record the confession. So the witness will tell something to the police. Now in the next stage, when he goes to the court, if he changes his statement given to the police, he becomes hostile witness. Okay, that is in this stage, inquiry. Here it is done by the judicial magistrate or the court. From here judicial proceeding starts. After police report, the magistrate or the court will verify whatever police has done is right or wrong, whether police have missed something or not. That will be done in the second stage by the judicial magistrate or to the court. Will verify the facts, determine the truth or falseness mentioned in the police report. In this stage also, if the magistrate or the court finds that the accused has not committed the crime, then there will be no charges against the person and the police and the person will be released. If they think that yes, he has done the crime, then in the next stage it is the trial. It is the trial. In the trial, what happens? There will be charges against the person. Okay, multiple charges. If the accused is already present in front of the magistrate, then it's fine. If he is not present, then he will arrest warrant or summons will be given to that person against the accused. It is the duty of the police to bring that accused in front of the magistrate. Okay. Now charges. Say for example, this person is accused of rape. So he will be charged under sections of rape. Now these charges will be told to the accused. Now he will be given a chance. Have you committed this crime or not? That is known as plea of guilt. He also will have a chance to say. If the accused accepts his guilt, it means if he accepts that yes, I have done this one, then the case is closed. Magistrate or court will directly deliver the judgment. No need to hear the other party. If he says that no, I have not committed this crime, then there will be hearing in the court. Hearing in the court means what you will do tomorrow. Two parties, one is the accused, one is the defense. These two parties, the lawyer will argue, they will submit the evidence, and then based on those evidence, the court will give the judgment, convicted or acquitted. This is the sequence, and it comes as a long question. This one. Types of legal system. You see these two photographs. What do you see? In the first photo, there is a judge who is not saying anything. Two parties, one is the accused, one is the prosecution. They are arguing with one another, and the judge is listening whatever is going on in the court. In the other photo, the judge is actively arguing. That means the judge is actively taking part in the investigation. Which one is prevalent in India? The first one or the second one? The first one. The first one is known as adversarial system or the common law system. And the second one is known as inquisitorial or civil law or continental system. In India, it is the first one which is practiced. The court will not be a part of investigation. That will be done by the police or by the magistrate. There will be two lawyers, two sides, defense and prosecution. They will argue. The judge will hear and see the evidence and he will give the judgment. Judge is not in favor of anything. In the second one, the court will actively take part in the investigation. Clear? You have seen this web series? At least one or two you have seen. If you have seen this, you will understand these procedures. First, the PP, the public prosecutor, will start the argument, and then comes the defense lawyer. Okay, you can go through this if you want to see the court procedure proper. You have seen this. These are related to forensic science and forensic medicine. They are also court procedures they have shown. In all these situations, they have shown the Indian system, Indian legal system, how it is done in the court. If you want to see what is done outside, then this is one web series. This is a Korean series, Partners for Justice. Here it is a team of forensic doctor. He is a forensic medicine person, autopsy surgeon. She is the magistrate. Both of them are forensic science expert. He is a police investigator, detective. All of them will be actively involved in doing the investigation. So types of laws, those were legal system. Now these are types of laws. Substantive and procedural. Substantive means what? These are the definition and punishment of offense. What is rape? It is defined. What is the punishment of rape? It is defined in BNS. Subsequently, we will take the classes. Procedural means the procedure. How to deal with a survivor of rape. How to deal with an accused of rape. How to do the examination. These are procedural laws. So, which one is the procedural law? BNS, BNSS or BSA? Or IPC, CRPC or IA? It is the BNSS. BNS is defining the offense and punishment. BNSS is the procedure for this one. So substantive is BNS and procedural is BNSS. What is statutory or codified laws? You have seen the Constitution of India. There are certain articles. By now you should know what is BNS, BNSS, BSA. There are certain codes. Section this defines this one, section this defines this one. These are the punishments. So these are certain codes. Means these are already present in the Constitution of India and in these acts or laws. So the court will give the judgment based on this definition, based on these codes. Non-codified or common means the laws are not written anywhere. Non-codified, not written in the Constitution of India, not written in BNS, BNSS or BSA, not written anywhere. These are some judgments which the court will give based on the previous judgments. They will not give based on what is written in the literature. They will give based on the previous judgments. Say for example, there is a famous case, Jacob Matthew versus State of Punjab. I'll not go into details because it is not relevant to you for in MBBS level. This was a case and this was a landmark judgment. The Supreme Court gave the judgment that a doctor cannot be arrested merely on the basis of a complaint. It was after this case. Opinion has to be taken from the medical board. So, police cannot directly go and arrest the doctor. But it is not written in BNS, BNSS or BSA or Indian Constitution Act. Okay, it was a new rule which was given by the Supreme Court based on some previous judgments. Civil laws and criminal laws. Differences they used to ask. What do you mean by civil law? What do you mean by criminal law? Civil law means one versus one. I have a problem with my brother regarding a land disputes. So, one versus one. This is a civil law. Criminal law means it is a matter of concern for the society. Murder, rape, culpable homicide, dowry death. These are all example of criminal case. If I murder someone, then if I am set free, then I can murder another person also. So, in criminal case, the government or the state will be responsible to fight for the victim. In civil law, it is one versus one, person versus person. In criminal law, it becomes the victim, that is the state, versus the accused. It is governed by CPC, Civil Procedure Code, and this is governed by BNSS. Who is affected? Only an individual, whole society. In civil case, there is no physical injury. I may have a land dispute with my brother. Until and unless I have a fight with my brother and I try to stab him. If I try to stab him and try to kill him, that becomes a criminal case. Until and unless there is physical injury, it is a civil case. So the trial will be in civil court. This will be done in criminal courts. Case citation: plaintiff versus defendant. Plaintiff means the one who will complain, who will file the case. He is the plaintiff. Defendant means the one who will defend. Defense versus prosecution. Prosecution means the victim side, that is the state. Okay, and another one will be the defense. Burden of proof. Burden of proof means legal responsibility to prove that whatever I am saying is right. In civil case, it is the plaintiff. If I am filing a case that my brother has illegally captured my land, if I file a civil case, then it is my duty to prove that he has done something wrong with me. And in criminal case, it is the prosecution. You might have heard this thing that an accused is innocent till he is proved guilty. So it is the duty of the prosecution to prove that he is guilty. If he is not proved, then he is innocent. Understood? Here, punishment may be compensation and injunction. Here, whatever punishments I have discussed. What is the meaning of injunction then? Compensation, you understand that, okay, you give me money, case is settled. Injunction means what? The court will tell to do something or to not to do something. Like if me and brother, we are having some issues. If my brother is found guilty, then the court will order him not to interfere in this matter, not to take my land. Okay, so this is an injunction. Recording of evidence. This photo I have shown in the last class. Tomorrow we'll have a role play on this one. Here, this is the sequence, Viva question. What is the sequence? First, it is the oath, examination in chief, direct cross-examination, and then re-examination. This sequence you should remember. What is the sequence of recording of evidence? Oath, examination in chief, cross-examination, and re-examination. What is this? He is taking the oath. You have seen this. He is a Hindu. So this will be which book? Gita. So before, it was practiced before. मैं गीता पर हाथ रखकर कसम खाता हूँ कि मैं जो भी कुछ कहूँगा सच के सिवा कुछ नहीं कहूँगा. For a Hindu, he will touch Gita and then he will tell this one. He will take an oath. For Muslim, it is Quran. For Christian, it is Bible. But this practice is not done now. Okay? He will do like this. Okay? And he will say this sentence. I swear in the name of God that what I shall tell shall be the truth, the whole truth, and nothing but the truth. You have to memorize this line. Okay, I swear in the name of God that what I shall tell shall be the truth, the whole truth, and nothing but the truth. Where is it written? Section 4 and 6 of the Oaths Act of 1969. You have to memorize this line. Okay. It is defined. What is oath? Declaration required by the law, which is compulsory for a witness before he gives evidence. It is compulsory. You cannot skip it. You have to take the oath. After oath, you are legally bound to speak the truth. If after oath you give false evidence, this is known as, if after oath intentionally you have given false evidence, then yes, starts with P, perjury. It is known as perjury. I'll change. Okay. What if you are an atheist? You don't believe in any god, you don't believe in ghost. Then instead of saying, here it is, I swear in the name of God. Instead of this line, you will say, I solemnly affirm. I solemnly affirm that that what I shall tell shall be the truth, the whole truth, and nothing but the truth. If you are an atheist, I solemnly affirm instead of swearing in the name of God. Oath is not required for a child less than 12 years. Very frequently, viva question. Who is not eligible or who might not have to take the oath? Any person who is below the age of 12 years is not required by law to take oath. If you do not take the oath, refuse to take oath, then you are liable to be punished. You have to take the oath. And when a person gives false evidence under oath, it is perjury. What is the section and what is the punishment? Defined in section 227 BNS. Punishment is defined in 229 BNS. Very frequently asked, not only in exam, in NEET PG also. Perjury and punishment of perjury. Imp means imprisonment. F means fine. Okay. The next step is the examination in chief or the direct examination. Here, the witness is examined by the lawyer of the party that has called him to give evidence. Okay. Public prosecutor will have his own witness. Defense will have his own witness. So, in a criminal case, the public prosecutor will first examine the prosecution witness. The PP will ask questions to his own witness. This is the first step. Main purpose is to bring all the facts relevant to the case, to place all facts known to the witness before court. Leading question is not allowed in this case, except in these two conditions. Leading question is not allowed in examination in chief or re-examination, that is the third stage, except in two conditions. If the court permits to ask the leading question, if the judge wants, okay, you can ask, then it's okay. If the witness is declared hostile by the court, in these two conditions, leading question is allowed in this examination in chief. Next will be what? Next will be this witness will be examined by the opposite party, opposite lawyer, that is the defense lawyer. Cross-examination. The lawyer of the opposite party examines the witness. What will be the objective? He will try his level best to prove the prosecution wrong. He needs to save the accused because he is still innocent. So the headache is with the prosecution, right? So he will try his best. He will try to elicit the facts favorable to the cross-examining party. He will bring up facts which is in his favor from the witness to test the accuracy of the facts told by the witness in the previous stage, whether he was right or wrong, to find out the weak points in the case, to discredit the witness and to prove that the evidence of the report given is not correct and a biased one. This will be the role of the defense lawyer in the cross-examination. There is no time limit for cross-examination. It may go days. Tomorrow you have 1 hour time. There may be court cases which has run for 3-4 days or even more. So here, leading questions are allowed in this stage. Re-examination, again, the same lawyer will examine. In case if the witness has done something wrong, not wrong, like wants to correct something, then in this stage he can correct. To rectify the discrepancy which may arise during the cross-examination, that is to correct any mistake the witness have made during the cross-examination. This is the objective of this third stage, and to clarify certain doubts. The question here is that the witness is not allowed to bring out new facts, to bring out new evidence. Understood? In re-examination, no introduction of new evidence by the witness. If he brings out a new point, then it will be cross-examined again. Now, my favorite question is, what is the role of judge? When can the judge speak in all these three stages? What is your answer? The judge can speak in the first stage, that is the examination in chief, the second stage, that is cross examination, or third stage, re-examination. In which stage the judge can speak? Yes? The judge will speak in any stage. The judge has the power to ask question in any stage. Let it be examination in chief, cross, or re-examination. He can ask questions anytime. Okay? This is not a part of the court procedure, but you should know about the conduct money. Sometimes they used to ask, what is conduct money? Like, I have a summons from Arunachal court next month. So my flight fare, my travel allowances, all these things needs to be paid. Okay? So this is a certain amount of money paid to the witness to meet his travel expenses for attending the court. This is known as conduct money. This is given only in civil case. Who will pay to the witness? Paid by the party who summoned the witness. Understood? Paid in the form of TADA. TA means travel allowances, DA means dearness allowances. Okay? So in the form of travel allowances, it will be paid. And it will be paid at the time of serving the summons. You just remember these few points. It is paid in civil case. It is paid by the party who has summoned the witness, and it will be paid in the form of TADA, and it will be paid when you go in at the time of serving the summons. Now, what if the conduct money is paid insufficient? I'll go to Arunachal Pradesh, flight fare, then taxi fare, all these things should be paid. Now, if it is not sufficient, then the question is, will I go to that court or not if I am not given the money sufficiently? The answer is, you have to go. Even if you think that the money paid is insufficient, you have to attend the court. You have to inform the court that the money given to you is insufficient. Then the court will decide how much money should be given to you, and it has to be paid to you. Okay, you cannot skip, you have to go. If the conduct money is not paid, then you are going for a civil case as a witness and the conduct money is not paid, then you have to inform the court regarding this one. Okay, conduct money was not paid and you have to ask for the money. Then if it is paid only in civil case, then what about criminal case? If you have to go for witness in my case in the Arunachal court is related to a criminal case, then homework, tomorrow I'll ask what happens to the conduct money in criminal case. This one, next topic is duties and conduct of a doctor in witness box. This one tomorrow we will discuss in details. This is the last slide. Tomorrow we will discuss in details. The point is, when you are getting the summon to attend the court, how you should prepare yourself, what you should dress, all these things matters. What you should speak, what you should not speak. So before reaching the court, you have received the summons. Listen it as a story. You have received the summons, you know the case, okay, I have been called to the court for this case. So before reaching the court, you have to be ready with all the documents. whatever you have given the report, go through the report, study about those points which you have written in the report. You have to be ready for that scene. Then when you go to the court, you have to first meet the who? The lawyer who has summoned you. That is a public prosecutor. You have to meet. Talk with him. You may have some confusion which you have to discuss with the PP. The PP also might have some questions which he will not know because he is a lawyer, you are a medical expert. Both of you might not know many things related. You might not know about law, he might not know about medical things. So you have to discuss and clarify the doubts. Then you have to give your attendance that yes, I have come for this. You have to show your summons, attendance. And in the witness box, this is the main thing. In the witness box, how you present yourself, what you should wear. Can you wear Crocs or not? You'll go to Crocs court wearing Crocs, wearing jeans pant. Okay, your button till this much is open. You cannot do like this. There have been some cases like that where an observer was scolded by the judge for not having proper dress code in the court. You have to be calm, you have to be patient, and you should know what to speak. More important is you should know what not to speak. Understood? And in cross-examination, the defense will try his best to prove you wrong. He may discredit you. He may ask you that, are you eligible for this, for writing this report? Then he may try to irritate you. Your qualification is not matching with the report. Your report is useless. He will try his level best to irritate you. But you should not be irritated. Okay, if you become angry, then it is a chance for the defense. And after giving the evidence, you cannot just run away from the court. You have to wait, greet the judge, then meet the lawyer or the public prosecutor, take the attendance certificate, and then ask for any expenses you need from the court. Once you are allowed from the court to go, then only you can leave. All these things we'll see tomorrow. What you do. Decide among yourself who will be the judge, who will be public prosecutor, who will be defense lawyer, who will be the accused, who will be the head of the department, who will be the head of the institute, who will be the security staff, who will be the stenographer, who is the stenographer who types, okay, and who all will be the observers, and I will observe the observers more. Okay, what you do? Clear? Okay, that is all for legal procedure. Next class we will start documentation, including your MCCD. So that will finish your legal procedure. After that, we will start identification chapter.